Oh gosh, I can't tell you my best Terry Connor story. Terry, in all honesty, Terry, I've been blessed with a number of great mentors in my life, and the best is Terry. Terry's the best lawyer I've ever seen. So Rod is actually my go-to guy to appoint when I need someone on a tough case, but that's only because I can't appoint Terry because he still can't practice in front of me. But Terry is the best I've ever seen on his feet in a courtroom. So
who's your go-to person in the guardianship? Can you appoint Terry?
Oh, yes. No, Terry appears in front of me quite regularly. He's spent a lot of time with me this year.
How does that work? I mean, so you get, pro se counsel that needs an attorney? How does that
Well,
appointment process?
in federal court, there's the CJA panel. In fact, Rod is on the CJA committee.
Right.
And there's a panel of attorneys in both Buffalo and Rochester who have been deemed qualified to handle these criminal cases. And with the assistance of the Federal Public Defender's Office, they are appointed to defendants who are qualified financially for the appointment of counsel.
Yeah. We're going to talk about best practices, and we got two real rock star counsel and two judges extraordinaire. And as far as just the curious, you've got federal judges here, and yet at the same time we have an outline that you prepared, Rod, with Terry, on state and federal courts. When you have a case, and when you have an opportunity, what is your thinking process as to which venue to place a case?
Well, I generally don't have that
Because you're defense.
that choice because the U.S. Attorney's Office has usually made that decision. If I had a choice, and it's probably only because it's what I've done for most of my career, which has been longer than I'd care to admit, but it would probably be in federal court because more important than, I think, knowing the rules or knowing the law are relationships and reputation. And from when you walk into the federal courthouse and you deal with what we call the blue coats or the security guards, to when you get in the courtroom and you deal with the judge's courtroom deputy, to the court reporter, to the judge, it's those relationships that you've developed over time that are going to determine, I think, more than anything, how well you do. There's a very well-known lawyer in Buffalo named Joe Sedita who once said that law is one profession that uniquely rewards age. And I'm finding that that's true. As you get older, if you know the players, I think it makes it a much more enjoyable experience.
We're the same age, I'm just curious. Terry, you do some civil work, and so sometimes you choose.
We do, and there are some very real distinctions between state and federal court, depending upon the kind of case that you have. That's what dictates where you want to be. Because one of the factors that you don't have control over is the selection of the voir dire panel. And keep in mind, when you're in federal court, they draw from 8 counties. When you are in state court, they draw from 1 county. So it depends upon the kind of case that you have, obviously whether you can satisfy the venue criteria to dictate where it is that you will select to place the case. That's the most important consideration. The second most important consideration is timing, because in federal court, Judge Gretny is often been quoted as saying they are the 7th busiest court in the United States. I'm not sure if that's true or not, but he says it all the time. But the problem is they're so busy trying criminal cases that if you have a civil case, there's a chance that you will not move along their docket very quickly. And that will dictate whether or not you feel as though it's more important to get the speed that's necessary to protect your clients and to achieve the outcome for your clients, or are you willing to wait because you may feel as though you have a favorable voir dire panel, or you may have a favorable body of law. Those, to me, are the most important considerations when you select which court you choose.
in jury selection.
Yeah. Well, I was going to talk about that later, for sure. But we want to talk about that when we talk about differences?
Sure, go ahead. Perfect.
All right. When Greg got a hold of us and said, talk a little bit about the differences between federal court practice and state court practice. Immediately, jumping to the forefront of my mind, so far ahead of any of the other issues, are the fact that in state court, Supreme Court, you get a chance to pick your jury by interviewing them, by interacting with them. And most of the shackles have been taken off so that you don't even have a judge with you. You get a chance, if you're doing your job correctly, to air your case out, to find out about jurors and their likes and dislikes, to do it appropriately. But it's exhaustive. You can find out so much more. In federal court, the judges pick the jury, and they have their own way of doing it. But honestly, the first interaction you have with the jurors in federal court is when you stand up for your opening statement. And I can tell you, sometimes it's a cool reception. You stand up an opening statement, and the jurors look at you like this. You know, that's not really a very good or auspicious beginning. But if you've had a chance to vet your case with them, to talk about whether it's burdens of proof or constitutional law, whether it's right to a trial by jury, whether it's, you really can invest them in the process in voir dire, in jury selection, it makes all the difference in the world. No comparison. I'd pick, if I had my choice, the chance to speak to the jurors beforehand.
In civil cases, I let the attorneys conduct voir dire. I don't in criminal cases. The one aspect that I think is a big difference between federal and civil court too, for civil cases, in federal court, it has to be unanimous, and it's typically 8 jurors. And I think from a plaintiff's perspective, that is more difficult than in state court. I mean, when I was in private practice, particularly from a plaintiff's personal injury standpoint, I would much rather be in state court as opposed to federal court. In many other aspects, I would prefer to be, even commercial cases, I would prefer to be in state court as opposed to federal court because the cases did move quicker. Wasn't always as thorough an examination as you might get of the legal issues in federal court, but at least you're getting your case to move along. And it's not because the judges in federal court aren't working. I can guarantee you we're working very, very hard, but the dockets are significant, and it makes the process slow.
If I could, I'm sorry.
Sure, go ahead, jump in.
Cut you off. Something I could mention, because again, as you're probably getting the impression, I'm almost always in federal court. A growing trend in our district is that the judges, and I don't think they all do, Judge Filardo, but maybe you'll change your mind, is we get the names ahead of time of the potential jurors. We call it the veneer. And it's been my experience with the judges in Buffalo, and I don't know, Judge Wolford, if you permit it, but we're able to get the names and add just the town or city address of the veneer ahead of time, a week or two ahead of time. And I don't do it because I'm a dinosaur, but what people who are skilled can do on social media in terms of finding out about the veneer ahead of time is just such a tremendous advantage. And I was talking to Chief Judge Geraci last night, and he was telling me, I thought he was kidding, but he wasn't, because when I joked with him about it, he didn't smile. He's selecting this jury today, and he said, I'll have that done in an hour and a half. And I poked him, and I said, Frank. And he said, no, really, I'll have it done in an hour and a half. And apparently he was serious about it. And so we talked a little bit about this investigating of the veneer ahead of time, and he's in agreement with that too. But what you can find out from that, if you have someone who's skilled in doing that, it doesn't level it with the state court experience, but it makes such a difference when you get into the courtroom to select the jury, if you've had that chance to do that social media search ahead of time. And there's rules on that. You can't deceive the system in terms of who you are, but what's publicly available, if you're able to get that information ahead of time, it really is a big, big help.
Do you do that, Terry? Are you out there scoping the social media?
Yeah, absolutely. In federal court, you cannot pick a jury without it. And the case that Rod and I just tried, we defended 2 police officers who were charged with violating the constitutional rights of 4 young individuals. And in the pre-jury selection, because Judge Scrutiny gave us the case earlier, gave us the veneer earlier, we were able to do a whole lot of things, and not the least of which is to find out from that panel that there was one woman, juror number 12, who was particularly supportive of police. And you were able to look at some of her Facebook postings, look at some of her other social media. And the jury was out 2 days, and we were counting on her. We thought that she was someone who was receptive to the views that we had expressed to our cross-examinations and to our closing remarks. And so the jury came back in, and it's, to me, as a former athlete, that's the highlight of the case when the jury comes. I could watch a verdict anywhere in any court, even if it wasn't mine. But you watch the jurors when they come in, and you try to get a hint or get something if you can. And she walks in, juror number 12. And in federal court, the first 8 jurors walk in into the first row and they sit down. The next 4 are in the top row. So when she walked in and sat down, she's directly across from me. So she is about where that gentleman is, right there. And that's exactly what she did. She looked at me and she went like this. So I turned to my client, who by then had his head in his hands, his whole life, his whole career is there. I said, we're good, we're good. What do you mean we're good? I said, we're good, we're good. And sure enough, and that was something that we picked up in social media.
And what's noteworthy about that is the juror was looking at Terry, not at me. I'm sitting there patting my client on the back. There's a lot more to the story, but I had none of the confidence that Terry had when they
So
announced
we're
it.
good, but I don't know about Rod.
I will say this, though. I allow the lists to be produced early if the attorneys want them, but I put restrictions consistent with our jury plan on what they can be
Right.
used for, because I did have an experience where after my jury came back, one of the defense attorneys still had the jury list and decided that he was going to have his investigator show up at each of the jurors' homes and surreptitiously videotape them to find out what they thought of his performance, whether or not they considered any evidence that they shouldn't have been considering, attempted to ask leading questions to, I think the defense attorney's theory was, well, these jurors must have gone outside the evidence in the case to convict his client, and therefore they must have gone on to the internet and social media. So I and the government actually started getting phone calls from some of the jurors. Afterwards, I ultimately got, through the defense attorneys turning it over to me, the videotapes that were produced. And after that, I guess I was burned, so to speak. And so I fully understand the need to investigate jurors before you start your trial, but I also need to protect those jurors and not subject them to this kind of what I viewed to be harassment. So I typically will issue an order putting restrictions on what can happen to the jury list.
And Judge Wolford, I want to assure you, I told Terry not to do that.
I know you did. And I had to have a very stern talking to Terry about it. No, we're joking about that. It definitely was not Terry.
But it raises an interesting question. I mean, the verdict comes out, and you always like to talk about when you got it favorable to yourself. But if it isn't, is there a way, to kind of quiz them, to find out what was some of the thinking behind that? I mean, I'm just curious.
Well,
Is there
after
rules?
this experience, I have also won't let the attorneys, and in federal court, the judge has the ability to do this. I have said you can't talk to these jurors without me being involved to some degree. So in civil cases, I'll say to the jurors, if you want to talk to the attorneys, you're free to do so, but you also don't have to. In criminal cases, because of this experience, I put more restrictions on it, because it really, these jurors, in this case, it was a 6-week trial. These jurors took significant time out of their lives to sit there, and certainly didn't expect some unknown person to be showing up at their parents' homes, at their homes, asking very intrusive questions. And it unfortunately soured me in terms of, because I always used to have the perspective when I was in private practice, and it always used to annoy me that in federal court, some of the judges would not let the jurors talk to the attorneys afterwards. But after that experience, I have changed my practice at least.
Is there any restrictions on the jurors? They get done, they're dismissed, they can go to the media and just have at it? I mean, you see that fairly frequently. Do you put any restrictions on that?
I don't know that you can
I'm not-
I don't put restrictions on it. I typically, I'll talk to all of my juries afterwards, and I tell them that and after this particular experience, I don't want to talk to them about the substance of the case. I'm happy to talk to them about procedure. I'm happy to talk to them about questions about the process, but I don't want to know what they discussed in their deliberations. And I tell them that I would encourage them not to discuss that with anybody else, because as far as I'm concerned, that's the sanctity of the deliberation room, and there's a particular rule under the Federal Rules of Evidence that protects against the disclosure of that information. I used to, before this experience, talk to the juries about, why'd you reach this conclusion, and have back and forth with them. But after this experience, I feel that even having the judge engage in that with them can lead them to believe that it's appropriate to talk about it outside the jury room. But I don't think as a judge you can everybody's got a First Amendment right. If they want to go talk about it, you're not going to be able to stop that.
Yeah, I always tell them, you can talk about it if you want to, and if you don't want to, you just politely say, I don't want to. And I think that sends the message to them that they don't need to. And I'll do the same thing that Judge Wolford does afterwards. I'll talk to them, but only about procedural stuff. I will not get into the substance of their deliberations at all. I don't want to know. I mean, all that can happen is I learn something that puts a knot in my
Exactly.
stomach. That's the only thing that could come of that.
I just had a trial last week, and I went into the deliberation room afterwards, and so I thanked them, and I said, so, any questions that you have for me? They're like, how many pairs of glasses do you have? I thought, okay, this is the type of thing that they're, sitting there thinking about.
What was your answer?
2.
Tab 5 of the booklet, the Booklet of Life, and I highly recommend, this is going to be a resource for everybody, is a memo, civil and criminal litigation in state and federal court, evidentiary differences, brought to you by Rodney Personius and Terrence Connors, and Kate Howard. Kate, she's here, still here? Yep, no, there she is, yeah. Thank you for doing that. Was there any surprise as you were putting this together, or frankly, what was the reason to put it together? And were there, as you do the research and Kate provides you some substance and some actual case, and you read it and you said, oh my God, I'm not sure I remember that. Was there any of those moments when you blew through that?
Well, to answer your first question, the reason we put it together is because you asked us to. You told us to. You said they got to have something.
That's true. So I can give them a big applause for that. That's why you get credit.
I think probably going through the exercise, for me, the biggest surprise is that there are so few differences in the rules of evidence. There are a few, but, and I went through this last night, and I tabbed them, and I sent a little email to Terry. There's maybe 6 or 7, some kind of significant differences, but the biggest difference is that on the federal side, you have a coded federal rules of evidence, and on the state side, you have here and there in the civil practice law and rules, certain evidentiary rules, but you don't have a code as you do on the federal side. That's the biggest difference, but my biggest surprise was there really aren't that many. When you look at the cases on the state side, compare those with the rules of evidence and the case law that's interpreted those rules on the federal side, there's an awful lot of similarities, very few differences.
Is there any surprise for you, Terry, when you blew through this?
Every time I ever participate in a seminar or preparation for a seminar, the only thing that surprises me is how much more I learn than how much more I share. And it's the same thing with this. This is a really good, solid primer to take a look at when you're about to try a case. Great evidence stuff, nice distinctions, esoteric provisions that you might not have at the tip of your tongue. So that's the only really surprise. And going back and looking through it, saying, wow, that is really an interesting point. That's a good point to remember. And I'll keep this and use it. So thank you, Kate.
Did you read this?
I haven't. I can't wait to.
While we're on the topic of evidence, one of the things that I'd like to point out, at least from my perspective, is knowing when you can object doesn't mean that you should object. And in a trial that I handled fairly recently, the lawyers were objecting every time they could object, and sometimes they had a decent objection. And I would sustain the objection, and the lawyer for the, object, they're referring to something that's not in evidence. Lawyer's trying to lay a foundation for something. I object that it's not in evidence, that they're reading from it. I say, yeah, I guess that's right. Don't read from it to lay the foundation. And then the lawyer who was asking the question would say, well, Judge, let me just offer it. And the defense lawyer would say, no objection. Well, okay, so why did we object in the first place to this? All we've done is focus attention on the document and wasted about 90 seconds. So knowing whether you can object is only part of it. It's whether you should object too, and you got to have a reason, you got to have a strategy, you got to have a plan. So knowing the rules of evidence is part of it, but having a strategy to use the rules of evidence is just as, if not more than, important.
Judge, the only thing, I'm sorry, Terry, the only thing that I would add to that is it's rare, but there are times, because I don't object, try not to object at all, but there are times when I do that it's not because of a rule of evidence, it's because I want to break up it's like the batter that steps out of the box, so.
Yeah, well, absolutely, and that's one of the lessons that I learned from Terry. That there are times, during depositions, during Terry, what's the phrase? The yes train. When you've got a witness who's on the yes train, so somebody's getting cross-examined, and the witness who's getting cross-examined is yes, 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 yes. Terry will warn witnesses not to do that because he says once you get on that yes train, it's hard to get off. But he'll also object in the middle of that to get to try to break up. So I'm not suggesting that's part of the plan that I'm talking about. You got to have a reason to object, not just because there's a technical violation of a rule of evidence. That's not a good enough reason to object. There's a technical violation of a rule of evidence, and the evidence is going to hurt me. That's a good reason. Or I want to break up a yes train. That's a good reason. But there's got to be a reason for it. That's all I'm saying.
So Professor Irving Younger, who in my judgment is one of the preeminent teachers of trial practice, says it this way: it's not knowing when to object, it's knowing whether to object. If you don't know when to object, you shouldn't be trying the case in the first place. And think about that. That's a very good rule of thumb. Although that's the last rule of thumb I'm going to give out, because I saw Tony Rupp up here earlier. He's a well-regarded defense lawyer that I'm not about to tell him any more of our tricks. But that's
I noticed he put himself outside the spotlight. I noticed that, yeah.
He's writing down up there.
If I could, Greg, I brought with me this little red book, which is called My Little Red Rules Book. And it has every single federal rule of evidence in it. It's only this big. It actually has cases in it, too. It's put out by the Federal Defender's Office, I think in the Eastern District of Washington. But this is if you're going to go into federal court, is handy to have. And then this was used in putting together the outline. This is one of two volumes of a book that's called Evidence in New York State and Federal Courts. So it takes every evidence rule and it gives a comparison between the federal rule and the state rule. So this is a great resource. I got a couple more. And if for civil, Connor's Federal Rules of Evidence is very, very good. And it gets into a little more detail than the little red book does, as you can see by the size of it. And then the last one is Federal Criminal Practice, a Second Circuit Handbook, which is a great, quick resource. One of the authors of this is John Gleason, who's a very, very well-regarded judge down in New York City, in the Brooklyn, I think. But yes, he's no longer. You're right. What a loss. But in any event, what I also brought that I'll leave on the corner when we go is I had somebody in our office copy the information for each of those, so rather than write it down now, you can just, if you're interested, you can grab one of these on your way out.
Wow. You now have more books than most law firms have in total.
Yeah.
Everything's online. Do you have those cheat sheet books too, judges?
Oh, I do, absolutely.
Yeah.
I mean, I.
Liz, no, we have it committed to memory.
We'll edit this, okay, we'll get it. So for the traps for the unwary, judges, that was one of our subtopics through that all, and we've got, folks who are variously general practitioners. Some actually find themselves, many of them find themselves in the court, but probably not as much as, Rod and Terry. Can you give some sort of primer to kind of help folks, just things to avoid, the traps?
Well, I think one of the observations I've made since being a judge is I am surprised by the number of attorneys who go to trial and don't know the rules of evidence, and I see this more in the civil setting than in the criminal setting, because civil trials are more rare than criminal trials, but some really, really good attorneys, really good firms, they go to trial in a civil case and they don't know the rules of evidence, and you gotta know the rules of evidence if you're gonna go to trial. Doesn't mean you have to know them if you're not on trial all the time, doesn't mean you have to know them in your everyday practice necessarily, but if you're getting ready to prepare for trial, you really got to read through them and make sure you understand them and understand the ones that are going to be relevant for your trial. I mean, you can predict that with some pretty good certainty as to what rules are going to come into play for a trial, and you really should be familiar with the law in that area before a trial starts.
Yeah, I'm amazed at the lawyers who don't know how to lay the foundation for a business record, and for lawyers who don't, especially, and Terry and I have had this conversation even since I've taken the bench, lawyers who don't know how to impeach with a prior inconsistent statement.
Or to refresh recollection.
Well, and I was going to say,
Yeah.
and use refreshing recollection as a replacement for impeaching with a prior inconsistent statement, which not only is evidentiary unsound, but is stupid strategically as well. So it's that always surprises me. Lawyers that don't know how to do those kinds of basic things, which are the kinds of things that come up all the time in a trial. So you really ought to have a handle on those kinds of things. And also, lawyers who want to refresh recollection when recollection doesn't need to be refreshed yet. You ask the question, and the person answers, and then they answer wrong, right? And so the next thing the lawyer says, well, let me show you that with this refresher recollect. Well, wait a minute, he hasn't said he doesn't know yet. You need to establish a foundation that he needs or she needs recollection refreshed before you can do that. So yeah, I agree with that. And I also think that you need to know your judge too. I mean, I don't have very many rules in my courtroom, so I let the lawyers walk around as much as they want to, and they can approach a witness without asking permission and all that kind of stuff. But the one thing that really pushes my buttons is disrespect in the courtroom. And I've had lawyers, I had one in a recent trial, disrespect a witness during a cross-examination in a way that I thought really crossed the line. That doesn't mean you can't ask hard questions. It doesn't mean you can't raise your voice. It just means that you need to have respect for everybody in the courtroom. And so that's something that would push my button, and lawyers who practice in my courtroom ought to know that.
Terry, Rod, you both give lots of speeches and presentations to law schools and to aspiring lawyers and young lawyers. What's the question you guys most often get that kind of maybe even surprise you as a question from folks who are trained in the law? That you try to maybe guide them in a different direction, or maybe surprises you that it's a knowledge that they are at least playing with that may be inconsistent with what's going on? Oft-asked question.
Can you think of anything, Terry?
Well, hands down, the question I get most often asked in settings like this, at seminars and with law students in law school, is how can you do both civil and criminal cases? How can you try both kinds of cases? And the reason I find that to be somewhat perplexing is, as I've said before, I don't really think it's that big a deal. I don't tell them that. I mean, I like the mystery that exists there. But it's the same rules of evidence. And so when I'm asked that question, to me, it's a little bit confusing because the trial of a lawsuit it's almost a morality play. It's a mosaic that you put together, whether it's civil or criminal, to make your presentation persuasive. It doesn't matter that it's in a particular substantive area or procedural area. It's still a trial. A trial is a contest between competing stories. That's what a trial is all about. And it's the same whether it's civil or criminal. So when I get asked that question quite a bit from law students and from young lawyers as well.
Just to pick up on that, and then I did think of something. One of the differences I've noticed, other than the burden of proof, which is significant between a criminal and a civil case, is the latitude that I think you as a cross-examiner are given with a witness in a criminal case, and especially an agent, somebody a law enforcement agent or a law enforcement officer. The latitude that I think the jury will give you in cross-examining that witness in a criminal case, I think is greater than it is in a civil case. I find that in a civil case, you got to be a little more careful how you handle a private witness as opposed to somebody who's a police officer. And I think it's partly, too, because of what the stakes are. You're trying to protect somebody who's being accused, where the outcome is a lot more significant for that client. So I think you can be more aggressive in your examination in a criminal case than you can in a civil. That's one difference in addition to the difference in the burden of proof. The question I've been asked probably the most is how can you represent someone if you know that they're guilty? And the answer to that's fairly simple, which is I've learned over the many decades I've been doing this that you don't make those kind of judgments. That has become something that's carried over into my personal life and has been very beneficial. I generally don't make judgments about anybody, about anything. Maybe it's because I've gotten older and realized how imperfect I am, but I don't make that judgment, and it's more that you view your role as making sure that the system works properly, and your role in that system is to make it as hard as you possibly can within the rules for the prosecutor to establish his or her case. So you fight hard, but you do it because you want to test that system as much as you can. So it doesn't make any difference to me. I guess the only difference it makes is in the few instances that I've had an innocent client, the pressure is so much greater. And in that case Terry and I just had, the pressure was far greater because of how we felt about our clients and whether or not they were complicit in this brutality that they were being accused of.
How does one pick and choose? Terry, I mean, you're on both sides. I mean, you do the plaintiff side, you do the defendant side. When somebody comes in and they present a case, how do you vet it? How do you vet whether or not you want to take that case?
You know, the standard has evolved over the years. When Larry and I first started, we'd take a hot stove. We'd take any case. And it's evolved over the years. For me now, I have two criteria. I like to work with good lawyers. You know, it makes such a difference. They raise your standard of practice. It's collegial. It's good, cohesive unit that you can put together. So I really like working with good lawyers. That's really important to me. And secondly, you know, a case, I actually care about my clients. I mean, I don't treat it as a business as much. And I learned that lesson a long time ago where someone explained to me that clients don't really care how much you know until they know how much you care. And I think that is the way in which you should guide your practice, at least at this stage of my career. So I like to have cases where I really think I can make a difference, where I care about the case, where I care about the client. And not to say I won't take a controversial one or I won't take one that's got a lot of adverse publicity, things of that nature. But I find that, you know, good lawyers and cases that I care about are really pretty much what guide my principles.
I'm glad you don't take any cases where there's some adverse publicity.
Yeah.
This is 60 Minutes.
You got to deal with that.
Yeah. Are you, by the way, are you on the 60 Minutes program?
No,
No?
no, we declined respectfully to participate.
Okay. as you know who the good attorneys are and who are not. And so when you make decisions as to assigning cases, is that a process? Do you talk among yourselves as to the judges, as to how you're going to assign counsel?
Well, I don't know if, for the criminal assignments, it's really not anything that Judge Velardo or I
Okay.
get that involved in. Sometimes the magistrate judges do, but it's also very, the next person up on the list will get the assignment. I mean, there's a list, it's administered by the Federal Public Defender's
Yes,
Office, I think.
right.
So
It is.
that really isn't something that
I
the
see.
judges get involved in. We do get more involved to some degree in assignment of the pro se cases. We have an awful lot of pro se civil cases in our district, a lot of civil rights cases dealing with prisoners suing the correctional officers for alleged violations of their civil rights. And in that regard, at least in Rochester, the ABOTA group, which is American Board of Trial Advocates, has a mentor program that they've established in Rochester where they pair seasoned trial attorneys with younger, more junior attorneys. The trial I just had was one of these, where Phil Spillane, who's a partner at Harris Beach and is a member of this ABOTA program, had a young associate from his firm trying the civil rights case on behalf of the prisoner who was suing, in my case, 17 different correctional officers for alleged civil rights violations. And in those cases, yes, I reach out to the individuals who I know that are part of this program. And it's a great experience for younger attorneys to have a trial in federal court. I mean, this young associate, this was his first trial. He did all the witnesses, he cross-examined the witnesses, he did the opening, the closing. It was a civil case, so he got to voir dire the jury. He lost, but it was somewhat predictable. But it was a great experience for him. And you're as a civil practitioner, you're not going to typically get that kind of experience. And I think as a young attorney, you have to try to reach out and find those opportunities. And that's one way to do it, by handling pro se cases on a pro bono basis.
And there are times in criminal cases, so I had a case recently where we needed cursio counsel, so there were conflicts of interest. And I chose the lawyers who I wanted in there because there was some thorny conflict of interest problems that I wanted to pick lawyers who I knew were going to be able to handle this. So we picked I think four lawyers for that. And there are also times when a particularly difficult defendant may ask for new counsel, and I'll get involved at that level with who the new counsel is, because there are certain lawyers who are able to handle those kinds of cases and some lawyers who are not able to handle those kinds of cases. So I'll look to folks like Rod in those kinds of situations. I have looked to Rod in those kinds of situations to handle some particularly difficult
I had a
people.
trial, and I think
Yeah, you
I
do too.
needed
Right.
an attorney for a witness who we knew all of a sudden may have
Right.
an issue testifying, and we tracked down Rod in the courthouse, called him out of Judge Arcara's courtroom, had him come up, and
I told Terry on the way down that I've had judge 3 cases in front of you, and all 3 of them were ones where you brought me in.
really?
Thank you, Judge, for those. No, I mean, Judge Velardo. Thank you,
Judge
Judge Velardo, for that.
Yeah.
Just curious, we recently had an anniversary CLE program on Attica, which brought into play Judge Teleska's rulings and a variety of personalities that were part of that. Heather Thompson, who was the Pulitzer Prize-winning author on Attica, was here. Lee Coppola spoke. It was interesting. Just curious, is there anything left over from all of those cases that came through the federal district court that's still out there? Is there anything that's, I realize that was 1980s when Teleska finally
I think
said.
Judge Teleska still has all his files. I know he does, because I've
But was
seen
it-
them, but I don't know that.
You haven't seen anything that would find?
I don't think there's any active cases still.
Yeah.
Not from the Attica cases. I still have a 1973 case from Judge Curtin on the desegregation of the Buffalo Fire Department that is still pending. Yeah, so I inherited all of Judge Curtin's cases, another judge that had an impact on me and was a good teacher for me. But I was honored to inherit all his cases, and two of the cases I inherited were the Buffalo Police desegregation case and the Buffalo Fire desegregation case. The police case has since settled. I'm pretty sure that I have it right. The police case has since settled. The fire case still has one outstanding issue. And I'm taking it very seriously because I know he's going to haunt me if I don't. So,
Greg, if I could tell one quick Judge Curtin story. When I was a prosecutor, one of the more senior assistants in the office had indicted a case where the main defendant was called Gas and Go, which was a gas station. And I think 4 people were indicted, and it had to do with evading sales tax on gasoline sales. And the theory of the case wasn't necessarily the greatest in the world, but I was the second chair to this prosecutor who had indicted it. And to our good fortune, I didn't mean sarcastic, the 4 lawyers who came in to represent Gas and Go and these 3 individuals, if you remember any of these names, Harold Boreanaz was one who was a spectacular criminal defense lawyer. Bob Murphy, who was a spectacular criminal defense lawyer who would come into the courtroom with literally just a yellow pad and nothing else, and he kept it all up here, and nobody was better on evidence than Bob. And Kevin Dillon, who later became Erie County District Attorney and then became a Supreme Court judge who passed away prematurely a few years ago. And the lawyer who brought them all together, whose name was Mike McGee, who wasn't the lawyer of the others but was very capable. So you had these excellent lawyers. It was in front of Judge Curtin. He didn't like the case. And so I got up to examine this one witness as a prosecutor, and I asked my first question, and Murphy got up and he said, "Your Honor, I object." And Curtin said, "Sustained." And I said, "Okay." So I asked the question a different way, and Murphy stood up and said, "Your Honor, object." Judge Curtin sustained it. And now I'm starting to say, I have no idea what the objection is. And this went on for 9 or 10 questions in a row where Murphy would stand up and object, and Curtin would say, "Sustained." So finally, I leaned against the podium, and I got the jury right here, and I looked at Judge Curtin, and I said, "Judge, I'm doing my best." And he looked at me, he took his glasses off, he leaned over the bench, he looked at me and smiled and said, "Mr. Personius, nobody ever said this would be easy." So I was like left there. It was just, but that's how you learn. You know, I mean, you talk, Judge, about how you learn. That's how you learn when you're, to the point where I was waving a white flag at that point. But by doing that, Judge Curtin became a little looser on the evidence rule, so I got through.
Great story. Judge Wolford, you must have had a similar story, the one where you're saying, "You're not going to believe this story happened to me in court," where it's sort of a knuckleball, it's out of unorthodox, it can be self-effacing, anything that's kind of a humorous moment?
Well, as a civil practitioner, a lot of what I did was depositions. I mean, that was a lot of my questioning of witnesses. And as a young attorney, especially a young female attorney, what stands out in my mind was I must have been practicing maybe just a couple years, and my adversary was an attorney from, no offense, guys, Buffalo, and he was just obstreperous. I mean, he wouldn't let me the minute I tried to ask a question, cutting me off and wouldn't let his witness answer the questions. And I mean, we spent 5 hours doing this. And especially as a younger attorney, I dealt with a number of other attorneys like that who could be, you're in a deposition, you don't have any referee, so to speak, because the judge isn't there, and you have people who take advantage of the rules and try to prevent you from being able to ask questions. And I think having gone through that experience as well as other similar experiences, at least it teaches you as a practitioner ways to try to deal with that type of situation. You're never going to change your adversary. You're not going to be able to bully a bully. I mean, my temperament at least wouldn't be able to do that. And you figure out ways that you can still try to advance your goal and get the information that you need from the witness, even under difficult situations like that. And that's why I go back to, I think you've got to be in those situations as a young attorney and figure it out as a young attorney, because it's very difficult to do that when you've been practicing for a number of years and haven't really kind of figured out what your means or method is of questioning a witness. I mean, I think one of the more important things that attorneys do, whether it's in the courtroom or in a deposition, is figuring out how to elicit testimony from a witness. And everybody's got a different style and method by which you get the information that you're looking for. And that takes practice. I mean, that takes years of practice, really, to be able to develop that.
All right, Judge Velardo, that story that you often tell when you get together with your colleagues and saying, let me tell you about the time this happened to me
The
in a
most
court.
bizarre thing that happened to me in court, I told this story to my law clerks on the way here, and it is pretty bizarre. So it's the first case I ever argued in the Second Circuit. I'm a second-year associate at Damon & Mori. Another law firm has retained me, actually, to go argue an appeal in the Second Circuit, and I think it's a pretty big deal. I've seen dozens of appeals argued in the Fifth Circuit. I know what an appeal looks like, and so I've got 20 minutes to argue, and it's a pretty sophisticated issue, and so I make my argument, and it's a really hot bench, and they're questioning me from the get-go, and I don't get through anywhere near my argument. The conclusion of my argument, Chief Judge Newman says, Mr. Velardo, we've taken up all your time with questions. You've got a lot more you want to say. We're going to give you as much time as you need. So I argued for an hour and 15 minutes.
Oh, my God.
Okay. During that hour and 15 minutes, Judge Van Grafflin, God rest his soul, is trying to pin me down on a question that's outside the record. And I know the answer to the question, and it's not good for my side, but it's outside the record. So I say, Judge Van Grafflin, with all due respect to the panel, the questions outside the record shouldn't be considered. I don't care if it's out. I want to know the answer to the question. And he's pinning me down, and I'm doing this dance with him when Chief Judge Newman interrupts and says, well, Counselor, maybe there's someone who can help us. There's someone waving his arm at the back of the courtroom. It's the trial lawyer. And he comes up to the podium next to me and answers this. I swear to God, this is my first appeal in the Second Circuit. And he's answering the question next to me that I don't want answered, and you know, helping the panel with the. I'm kicking him from behind the podium, and he sat down. So yeah, it didn't do any good. You know what I'm talking about too. Yeah. So what that taught me was be ready for anything in the courtroom. And as I say, I was a second-year associate. That's the most bizarre thing that's happened to me during, and it's pretty bizarre, I think.
All right,
and especially in the Second Circuit, right?
Yeah.
So.
It's tough to top, but I can tell you, I was trying a case up in Niagara Falls. This was years ago. I was, relatively new and inexperienced, but it was a personal injury case for the daughter of a Supreme Court justice who had asked me to take over the case. And I was only too glad to do it. It wasn't a bad case. And I have a habit when I'm on trial, especially in state court, I stay in the courtroom during lunch breaks and I stay during other breaks. I'll even eat food in there. I like to be working at my desk. I like to take advantage of the hour and a half I have to work. And I guess it looks pretty intense. So I'm in there one day, and by myself, working away. And, the jurors in the state court system, they walk back and forth. It's not as confined. They don't go into the room. They walk around. They come back in. And I must have been doing something correct because the defense lawyer decided he was going to stay in the courtroom as well. So the defense lawyer is sitting over at that table. I'm sitting at the table, and in walks a juror. Okay. Now I'm working at my desk like this. I'm slaving away like this. And the juror walks over behind me, stands right behind me, and starts going like this. Swear to God. And she goes, it's going to be all right. And she walks, and she goes into the jury room. Now, the defense lawyer is sitting where Rod is. All I could do, great guy, Tom Bitter, nice guy. All I could do is he looks like this, he goes, oh, God. And the jury get exactly what I asked for, to the penny, exactly what I asked for. That's a true story.
Was that juror number 12?
I keep her around whenever.
I can share one other quick one from when I was in the U.S. Attorney's Office, and our first assistant, who was just a wonderful guy, and still is a wonderful guy, But he wasn't known for Mr. Preparation, so he's trying a tax case up in Judge Curtin's courtroom. And at this time, the U.S. Attorney's Office was on the 5th floor of the old federal courthouse, and Judge Curtin's was right above that. And when grand juries sat, and this is still the case, if they return an indictment, the foreman of the grand jury will go with the prosecutor who put the case in, and if they vote an indictment, they have to report that to the district, one of the district judges. So Roger's trying this tax case, and he gets done. I gave his name. The first assistant gets done with a witness, and he's got to call the next witness, which is a records witness from a bank who's going to help authenticate bank records to get them into evidence. So Roger calls the witness's name. Nobody enters the courtroom, so Roger leaves the courtroom, goes out into the corridor, and grabs this person and brings him in, has him get sworn in. He gets up on the stand. Roger asks him his name, asks him his address, takes these bank records and shows them to him, and this guy looks at him and says, "I've never seen these before." Roger didn't know who the custodian was going to be from the bank. He had pulled the foreman for the grand jury who was waiting to go to the courtroom across the hall and put him on the stand.
That's good. That's good. So, Terry, what's a question you want that I should be asking Judge Villardo this moment as we wrap up?
Oh, God. Is he permitted to invoke the Fifth Amendment?
He's the judge.
Yeah, he is. Well, I suppose if after all these years and the great desire he's always had to become a judge, whether it's really fulfilling his career goals, whether it's something that is what it was made out to be.
Yeah, the answer is yes. I mean, I feel like I'm doing what I should be doing now. That's not to say that I didn't love practicing law with Terry and our other partners and associates at the firm. I did. When Judge Wolford was talking about how much she loved practicing law and that she would have been perfectly content continuing to do it and that being a judge was not on her radar screen, I thought to myself, while being a judge certainly was at my radar screen and was a goal of mine, I also would have been perfectly content practicing law for the rest of my life. In fact, when Senator Schumer recommended the woman for the first opening, and I thought my aspirations were over, I wasn't devastated. I was sad. I was disappointed, but I wasn't devastated because I said, you know what? I got one of the greatest jobs in the world right now, and I'm more than happy to continue to do that for the rest of my life. But having said that, I feel like I'm accomplishing something, and I feel like I'm in the right place for me right now. I think practicing law for 35 years with Terry was 35 years, was it?
Almost.
Yeah. Was an amazing experience and a great experience, and prepared me very well for what I'm doing now. But yeah, I'm very happy to be where I am now.
Okay, Rod, you being one of the foremost questioners of all time, what's the last question we're going to have today of Judge Wolford?
Oh, yeah, good, because I had thought of one.
I have one.
When your father was throwing those snowballs at Foreman, were you the one that handed him the? I used to go to a lot of Bills games.
Yeah, we used to have season
when I was
tickets
at
to the
Brown and
Bills,
Kelly,
too.
So it was your fault, huh?
and it turned out that our seats were right next
Yeah.
to Liz and her dad. So it goes
Yeah.
way back. But anyway, that's not the question. The question, Judge, would be: you've been on the bench now 3 years?
5.
Oh my God!
5 years this December.
What's the hardest part of your job?
It's actually interesting, because at the White House interview that I went to, they said, what do you think is going to be the most difficult challenge? And I had no real criminal experience, and one would suggest that probably learning that area of the law, which frankly consumes at least more of my court time than anything else, would be the most challenging. But I said at the time, and I still think this is true, that it's an isolating job. It's you come from a firm environment where you work as a team and you have colleagues and you're constantly bouncing ideas off each other in terms of what the best strategy is with a case. It's not, I have wonderful colleagues on the bench, but it's different because you each have your own case law You work with your law clerks, and it's wonderful working with law clerks. They're bright, young, energetic, enthusiastic attorneys, but you don't have partners who you are working with on a case. And that there's some days when I don't have court where I go into the office and I only see the people in my chambers, which is a total of 4 people. And that is challenging. That was by far the most challenging right when I went on the bench. I found that very difficult. I think after 5 years, you become used to it, and it's a wonderful job. I mean, the breadth of the issues that are in front of you and your ability to really make an impact, as Judge Villardo said, and to have the ability to write decisions. I mean, it's a wonderful opportunity, but that is by far, I would say, the most challenging part of the job.
The only thing that's standing between you folks going downstairs and enjoying the cocktails and me is simply thanking this panel. This has been extraordinary for the 4 of you to come down. These are really busy people. And to come here and share this is terrific. Two things I would ask, well, actually 3. One, make sure you fill out your sheets, hand them to Mary Keating over there. 2, this panel would stay right there, we're gonna take a quick picture. And 3, please raise a glass downstairs as you mingle to Judge Villardo 3 years ago today. Today. He was gonna buy drinks, but he said he'd opt out to let you buy them. That's the kind of guy he is. This is a special celebration. Again, thank you so much.
Thank you.
Thank you, Greg.
It's fun.